Hi, my name is Paul Newharth, and I'm a criminal defense lawyer in San Diego, California. I've been practicing for 24 years. Prior to that, I was a state police officer for 7 years. Actually went to the FBI Academy and participated in hundreds of DUI arrests. As a criminal defense attorney, I have 3 published cases, both against the Department of Motor Vehicles and against the District Attorney's Office. Done a number of hearings, many hundreds of DMV hearings. I was named the top attorney in San Diego for criminal law in 2011 with the San Diego Daily Transcript. Been a top 100 trial lawyers in California with the American Trial Lawyers Association for approximately 8 years. President of the La Jolla Bar Association, an AV-rated attorney for approximately 18 years. In addition, I've lectured for the California Judicial Council, the Public Defender's Office, the San Diego County Bar Association, the San Diego Trial Lawyers Association, Criminal Defense Lawyers Club, Criminal Defense Bar Association, San Diego County Public Defenders Association, and various groups that ask me to come in and speak on different topics from DUI to Department of Motor Vehicles law, and in some cases different criminal law aspects that are really non-homicide cases. I'm here to speak about DUIs, probably geared towards the general practitioner. I consider it more of a how-to do a DUI case. Primarily this will happen when you have a friend, a relative, or a client that says, I've been arrested for a drunk driving offense, what do I do, can you help me? Sometimes the person will be in custody, sometimes they'll be out. If the person's in custody, they can a lot of times be released with bail, or in some situations released on their own recognizance. In San Diego, they used to be released on their own recognizance on a routine basis, but now the bail is set at $2,500. They need to either post a full $2,500 collateral with the San Diego County Sheriff's Department, or they can pay a bail bondsman to make that for them. Once the client comes into your office, they're going to bring in the paperwork that they've received, usually from both the Sheriff's Department and from the Sheriff's Deputy himself, documenting the seizure of the driver's license for the DMV. When you see those, you should have a couple things to keep in mind, one of which is that you have a time limit or a statute of limitations in which you can actually contact the Department of Motor Vehicles to set up the DMV hearing. When you make that request within a timely manner, you request that the DMV stays the license suspension, issues your client a new temporary driver's license. You also do a written request for discovery. The DMV discovery is in many cases similar to or identical to the discovery you're going to receive in the criminal case. The plus on this is that you're going to receive that discovery at least 2 weeks or more before you're going to receive it in the criminal case. It'll help you to better prepare what you're going to be doing when you make the criminal court appearance. Once you receive that DMV discovery as well, it gives you the opportunity to issue subpoenas for certain documentation that you may want for the DMV hearing. It also gives you the opportunity to review with your client if you want to have your client testify. In many states, the client's testimony at the DMV hearing cannot be used in a subsequent prosecution and the case in chief, but it can be used to impeach your client if the client testifies at trial or testifies in court, contrary to what they testified to at the Department of Motor Vehicles hearing. So it's really important to keep in mind, if you're going to have your client testify for the DMV, not to have them say anything that's going to come back and later be used to haunt you or used to impeach them. Having the client testify is really just sort of an augmentation to using an expert or using other witnesses. Client's testimony in and of itself at a DMV hearing will almost never be sufficient to overcome the license suspension that's based upon the arrest from the DMV. You're really going to need to follow that up with subpoenas for lab records, criminal records, subpoenas for witnesses. Your decision as to whether or not to subpoena the law enforcement officer is going to be crucial here. If you choose to subpoena the law enforcement officer, you need to realize that there's going to be a cost associated with that subpoena. The law enforcement agencies will normally charge something in the area of $100 to $150 an hour for the officer being available for court, or for the DMV, which is a minimum of 3 hours. Why is it so expensive? Well, the county or the state actually charges, in addition to the officer's salary, charges the overtime rate, charges the cost of the officer's pension, the cost of any additional associated expenses with the support staff, the cost of making arrangements for the officer to be there. Your option, though, is not to, you can't decide not to have the officer present if you choose to subpoena him and you've posted that money. The important thing is that if your officer is going to show up, be sure that you're going to link in testimony that you can later use in your criminal matter as well. If the officer doesn't show up, of course, you do have a remedy now at the Department of Motor Vehicles because you have been not given the right to confront and cross-examine that witness against you. Also, be aware that if you subpoena the officer and you don't make that payment to the law enforcement agency, that they actually will forward it to a credit agency, and at some point in time you're going to have to pay that off or it will affect your credit. The licensee, though, your client, if the licensee actually claims that they're indigent or does not have the ability to pay for the officer, the DMV must in fact subpoena the officer, and if the DMV subpoenas the officer, you and your client are not responsible for any associated fees with that when the governmental agency is doing that. There is published case law that indicates that if a person is unable to afford for the officer to be present at the DMV, that in fact the Department of Motor Vehicles must subpoena that officer and must bear the expense. That's an aspect to think about. Other aspects to think about are the ability of your client to speak English. Is it the native tongue? Is it something where the officer spoke to them in English but they had a limited ability to understand? That's something that you will know with your interaction with your client. But if you're going to do that as well, you make sure that the Department of Motor Vehicles knows that your client is not able to speak English without the aid of an interpreter, and make sure that the Department of Motor Vehicles provides an interpreter for your client, which they must do at no cost. We're going back now from the DMV back into the criminal case. With the criminal case, you have the first court case coming up, and that is called the first court appearance. That's known as the arraignment. At the arraignment, you would normally enter a not guilty plea. The only time that you would really contemplate entering a guilty plea at arraignment would be under the following circumstances. If you knew that your client had uncharged DUIs that were not listed on the complaint, and there was a fairly good chance that the prosecutor was in fact going to be able to locate those DUIs and subsequently charge your client with them. If the client's DUI is really not defensible, then you might want to contemplate doing a change of plea at that point in time at the first court appearance to keep them from being able to amend the complaint later on and file the additional prior convictions. Also, if it was a DUI with an accident and you believe that the other person was injured or may be claiming injury, it's going to be important to get that change of plea done at the misdemeanor arraignment. And I say misdemeanor arraignment because if it has injuries associated with it, then we're dealing with a felony DUI. So if it's a misdemeanor DUI, you're doing the arraignment, you think that there are no other cases that are out there, no other charges that will be filed, and it's not involving a traffic accident with a potential for injury, then what you'll want to do is enter a not guilty plea, and then you'll get copies of the discovery also. There may be other reports that the DMV did not provide you that you may get from the prosecuting attorney's agency. Once you have those reports, and a lot of times they may be available in an electronic format through e-discovery, or they're simply paper reports, you have an opportunity to pick those up and review those with your client. Depending on who your prosecutor is, depending on what your case is, of course, depends on how you're going to resolve that matter, whether it'll be early in the case or later in the case. With the early dispositions, after arraignment, it would be at the first readiness conference. Readiness conference is a negotiation session, similar to a civil case management conference that you would have in a civil matter, or a status conference in family law. We call them readiness conferences here, or pretrial hearings in the criminal format, and that's your opportunity to present what you have on the case and show what you can do for negotiations. When you're dealing with the prosecutor, important things to bear in mind with the prosecutor are going to be the blood alcohol level on the case. Was there bad driving? When you reviewed the reports, did the officer indicate bad driving, or did he indicate that the stop was for an equipment violation, expired registration, for example, or tinted windows? Certainly, being stopped for a non-moving violation tends to show that the individual is not letting their driving become impaired by the alcohol or the drug that they may be on. Looking at that again, you'll look at the field coordination tests. How did the person do in the field coordination tests? It's interesting to note that when you review the police reports, in those cases where the police officer knows what the blood alcohol concentration is, specifically with the breath test, and if he sees that it's a lower concentration like a 0.08 or 0.09, he invariably will make the report look worse. It's hilarious because an 09 DUI with field coordination tests, the person's stumbling off the line, they're almost unable to follow the instructions. But if they come back as a 1.3 and the officer knows that and sees that when he's writing his report, you'll notice that the number of errors are greatly reduced and minimalized as he no longer seeks to justify the arrest for being under the influence of alcohol. So that's something you can point out to the prosecutor as well. Looking at the reports as well, you're looking to see what, if anything, happened as far as time-wise. When was the person stopped? When was the test given to them? Field coordination tests, when were they given? A lot of times, attorneys look at this and they say, wait a minute, Miranda rights weren't given here, and the officer was asking questions of my client in the field, and after they arrested them for DUI. Well, interestingly enough, Miranda rights do not have to be given in a DUI arrest or detention until the person is actually booked into a jail or holding facility or being questioned at the police station. The U.S. Supreme Court has ruled that a DUI arrest by itself is viewed as a transitory detention because the officer may subsequently learn that the blood alcohol was very, very low and may in fact let the person go, in which no charges are filed. So they do have to in fact allow those statements in, and they don't have to give Miranda admonitions. Now the client can always refuse to answer these questions, and in refusing to answer these questions, they're not held liable for that. You can't be judged. You can't have a jury instruction saying that you exercised your right to remain silent. Let's look at the type of testing as well that may be conducted in field coordination tests. Field coordination tests are going to be based upon both some ability to recall the instructions of the test, the ability to use your mind, and the ability to look at coordination. One of the most simple tests that's always given is called the alcohol gaze nystagmus test. And the officer is looking there to see if there is an involuntary movement of the eyes. And it's a tracking test that's done with the eye muscles. And in that test, the officer is asking the person that's being tested to follow the end of a pen or some other object with their eyes. The officer then will move the pen back and forth. What he's looking here for is an involuntary movement of the eye, if you're unable to smoothly track the eye or the pen or the object with the eye. So if an individual has a 0.08 or a 1.0 blood alcohol level or above, you will see that the eye follows in a jerky movement. With a 1.0 at a 45-degree angle of onset, you will see that the eye is rapidly moving here, and the individual is not able to control that. So you may not even know that your eye is moving. No amount of training, no amount of tolerance to alcohol is able to change that involuntary eye movement. However, this test is a voluntary test. The client doesn't have to take the test. It's also important to note that after about 2 o'clock in the morning, the training indicates that the angle of onset that's viewed should be at a 40-degree angle of onset and not a 45-degree angle of onset. The reason for this is ocular fatigue. As an individual goes later at night, their eyes become more tired, the eye is more sensitive and is more prone to having the nystagmus at an earlier degree of onset. So training dictates that after 2 in the morning, a 40-degree angle of onset should be utilized. Now also you should know that in about 3 to 4% of the population, this nystagmus actually occurs naturally. Irregardless of alcohol use or intoxication, this will still be present. There are also certain drugs that a client may take, both prescription and non-prescription medications, that can cause the nystagmus to occur. This horizontal gaze nystagmus, though, is primarily used for alcohol detection. There is also a vertical gaze nystagmus that is used for detection of PCP and some other controlled substances. This will be the first test that the officer gives because it can oftentimes be administered while the individual is still seated in their car. If the officer then believes that he sees nystagmus, he will ask the client to exit the car and give them an additional series of tests. Most of you have seen on the different TV shows, obviously, the walk and turn test, the one-leg stand test. These tests are designed, just as importantly, to determine whether or not the individual can follow instructions as to how they complete the test. In the one-leg stand test, the defendant or client is being asked to stand with their heels together and both arms at their sides. Then the officer asks them to raise one foot, either their right or left, so that their heel is approximately 6 inches off the ground. At the same time, he wants them to count rapidly from 1,001 to 1,030. Things that they're going to be looking for in evaluating the proper performance of that test is, number one, if the person remains at attention during the administration of the instructions. Number two, are the hands kept at the side during the testing, or is the person raising their hands and sort of fluttering with their hands to help maintain the balance? Number three, most importantly, are they able to keep their foot off the ground? Realistically, people are not exactly 6 inches. They may be 4 inches, 8 inches. But as long as the foot doesn't touch the ground, that's really the litmus test in evaluating this particular field coordination test. So if they can keep that foot off the ground for 30 seconds, they really are viewed as passing that test. There's also another test, which is a walk and turn test. And the individual is asked to follow a line. Usually it's going to be a parking demarcation line in a parking lot, but it may be just a straight line that the officer has drawn with chalk. In some cases, the officer will just simply ask them to try to walk in a straight line and to turn around and come back. Now, what the officer is looking for in this test is, can the person stand heel to toe with their arms at their sides while he is giving the instructions? Because most people will start off that way. The officer then is continuing to talk to them and give instructions, and they'll take their foot off the line and they'll stand with their feet side by side. That, though, is viewed as the inability to follow the simple instructions for the field coordination test. So they need to keep one foot behind the other while the test is being administered, and when they're doing that, the officer will then tell them to take 9 heel-to-toe steps down the line, turn around, and take 9 heel-to-toe steps back. What he also wants them to do is to keep the last foot, the number 9th step, keep that foot on the line, and then to use the other foot to pivot, and then take 9 heel-to-toe steps back. The officer is looking to see whether or not the person follows the instructions, whether or not they touch their heel to toe together, whether or not they count 9 steps, whether or not they actually keep their foot on the line as they pivot on the return, and if they do 9 steps back. A very good way of doing that is to make sure that the client actually puts their foot on the line and drives their heel back into the front of the toe to make sure there's no gap. That's how to properly complete this test. Certain other agencies will use other field coordination tests as well. They're designed to look at the ability of the mind to function. One that's very popular within Southern California is counting backwards from 75 to 55 or 100 to 75. And in that case, they're looking at the person counting backwards to see if they're going to skip numbers or if they're making pauses. So if the individual is counting backwards 75 to 55 and does that completely without any missed numbers and without stuttering, that's viewed as passing that test. Also, the alphabet is given. It may be given in a written format, or it may be given as an audible recitation of the alphabet. Specifically, the officer does not want the person to sing the alphabet. Even though if they sing the alphabet and they get it correct, it can't really be used against them, and a lot of jurors will actually understand that singing the alphabet is easier for people to remember the alphabet. Officers will almost never ask the person to write the alphabet down unless they are positive the person is impaired. And then you'll get a really bad piece of evidence in the form of a paper in which the person has scrawled out indecipherable letters, missed letters, gone backwards, done any number of things, and then it's a failed test, and also you have a written record of it, so it's just not the officer's word as to that test. Other jurisdictions will use what's called the Romberg test. The Romberg test actually is designed to measure an ability of an individual to estimate 30 seconds. And in that case, the client or the defendant is asked to stand with their heels together, their arms at their sides, to tilt their head back to close their eyes, and to estimate 30 seconds. Now, what is really looked at here is how much sway is occurring. So if the person is standing at attention and there's a normal sway is going to be 1 to 2 inches off of center. Anything more than 2 inches off of center is going to be viewed as having alcohol affecting the equilibrium and the person's ability to focus on keeping themselves upright. Because at the same time, they're required to focus on estimating 30 seconds. What is not so important here is the estimation of 30 seconds. Estimating 27 seconds, 25 seconds as 30 seconds is not a big deal in these tests. However, maintaining yourself at attention, keeping the head back, keeping the eyes closed, and not swaying all over the place is deemed as being necessary to complete this test. California Highway Patrol also uses a test in which they ask an individual to count on their hand. 1, 2, 3, 4, 1, 2, 3, 4, 4, 3, 2, 1, 1, 2, 3, 4, 4, 3, 2, 1, or 1, 2, 3, 4 each way back and forth depending upon the officer. They want the person to rapidly increase the touching of the finger to the thumb to the finger. And the goal here from the officer's standpoint is the faster the person goes, the more likely they are to miscount and mistouch the fingers. However, the person doesn't have to go fast. All the officer can say if the person continues going 1, 2, 3, 4, 4, 3, 2, 1, 1, 2, 3, 4, 4, 3, 2, 1, and doesn't pick up speed, the officer's only going to be left with saying that test was completed properly, but they didn't speed up when I asked them to. So, of course, that's going to look good for a jury. It's going to look good for a prosecutor as well. And that's something to keep in mind when you're reviewing those field coordination tests. Some officers still do the finger-to-nose test. Even though that is not done as much now, it's sort of fallen out of disfavor. But in that case, the individual is asked to tilt their head back, close their eyes, put both arms out to the side, and what the officer will do then he'll say right, and they're to touch the right index finger to the tip of the nose, left, or he may mix it up and give right, right, and then left. The officer here is looking to see if the individual is touching different portions of the face. And believe it or not, that actually happens. But that's more in an advanced state of impairment, really not at somebody who's an 08 or an 09 or a 10. So you don't see that test used a lot unless somebody is really unable to really do the other tests and the officer just wants to have that as icing on the cake. Lastly, the portable breath test or the preliminary alcohol screening test, or in some cases, in some states, it's known as the PBT or preliminary breath tester. That's used to measure the person's alcohol at the time of the arrest with a handheld device. What you get confused with, though, a lot of times is the same handheld device can be the actual required chemical test if, in fact, it is plugged into a unit in the trunk of the car. So let's say, for example, we're talking about the PAS, the 8000, the Gold Dot. This device is able to actually store within itself results of past tests. It can do calibrations. It can do air blanks. However, the client is not required to take this test unless the specific state requires the preliminary breath test administration. In California, it's not required to be taken unless the individual is under the age of 21 or is on a DUI probation, in which that probation is not being allowed to refuse that test. There are specific DMV consequences that go along with that, but we'll go into those later on. So that person then takes the preliminary alcohol screening test. The officer is not required to show them what the results of that test are. However, rest assured that the tests are going to come back. If they come back as an 08 or an 09 or a 10, they're going to be used in the police report. Now, there is an admonition in which the officer is supposed to tell the person that this test may not be used against you and this test does not take the place of the regular chemical test. However, if the officer doesn't tell the person this, then they may think that they have taken the regular chemical test and they may refuse to take another test later. What's also confusing is the officer may take that little handheld device and then plug it into his trunk, and all of a sudden now it becomes the mandatory test or mandatory breath test. Many states now have outlawed the urine test as being grossly inaccurate. But the breath test and the blood test are still used in the majority of states in the United States. The threshold level of the 0.08%, of course, is set by the federal government. And the reason why the states have gone to the 0.08% as opposed to the 0.10 was because federal highway transportation funding was conditioned upon the states actually changing their blood alcohol concentrations from a 0.10 to a 0.08 to comply with the federal norms, and they all, of course, did that because they wanted to have their funding. The last holdout was Montana, but Montana did come around to that. So you're looking at that 0.08%, and your client's either got the 0.08% blood or 0.08% breath. And you want to know, what are you going to do with that? What can be done? How can you utilize this inaccuracies that may exist? Let's start with the breath test. The breath test has the most number of attacks available against the breath test. The breath test is really conditioned upon the individual having blown a breath sample that really has a partition ratio of about a 2100 to 1. 1 part of alcohol to 2100 parts of breath. The problem, of course, with this is that this partition ratio is the result of an average of people's partition ratios within the number of studies that were conducted. Different individuals may have different partition ratios, 1300 to 1, 2800 to 1. And those partition ratios would directly affect a breath alcohol to blood alcohol relation. So the 2100 to 1 primarily is used for showing a 0.08% breath alcohol is the same as a 0.08% blood alcohol, because the statutes require a blood alcohol level. However, if your client has a different partition ratio, you're not going to be able to actually extrapolate that directly to a 0.08. Now in California, you're really not able to necessarily argue partition ratio evidence. However, you can argue the inaccuracies of the breath test. And one thing that you may be able to do, and which is extremely beneficial, is to look at your individual client's partition ratio. This is not an easy thing to do. This actually entails going to a crime lab and setting up a scenario in which your client sets aside half a day with the driver, and you actually do a reenactment of the eating and drinking scenario that led up to your client's arrest. And what you're going to be doing is giving the client alcohol and also doing a blood draw at the same time as the client is giving a breath test. And when you see that the person is in the absorptive phase, you'll see that the blood alcohol level is going to be lower than the breath alcohol. And that's going to be really a fascinating aspect for you, because you can actually get the a lab to show that, hey, my client, maybe he blew a 0.08, but his blood alcohol level would have been a 0.05 at that point in time. And so therefore we can show this, and we can prove this if we go to court. And I've been able to use this very successfully in getting cases negotiated down or reduced or dismissed for clients. It works very well when you can actually do an accurate reenactment. Where, of course, we run into a little bit of difficulty is when the client starts to burn off alcohol. And when they're burning off alcohol, what you'll actually find is that the blood alcohol level may be a little bit higher than the breath test. You're not in the absorptive phase now, you're burning out. And we'll talk about what an absorptive phase is and what that means in just a minute. But in that case, the client may actually blow a 0.08%, and the blood test will actually be a 0.10 or a 0.11. Where you really see this is where clients take a breath test, and then the officer says, you have a right to have a blood test as well. Well, the client sees their 0.08 or their 0.09 or whatever their numerical value is and says, I can't be that high. I'm taking a breath test. I'm taking a blood test. They take the blood test, and the blood test comes back from the crime lab as a 0.10 or a 0.11, a 0.02 to 0.03% higher than the breath test. So now, of course, the prosecution has the ability to use this higher blood test, and it really negates the ability of you to negotiate using that lower breath test, even though you can argue jury confusion at that point in time and still probably get a reduced charge. This really works across the board, even though at the higher blood alcohol levels, you may see higher extremes in the variations. For example, a 1.8 breath alcohol may show up as a 0.22 blood alcohol. And then, of course, you've got a real problem that you're going to be dealing with in negotiating that case or resolving that case for your client. So that's where you normally see the different partition ratios actually being used in a extrapolation of a breath to a blood test, and the use of that in a prosecution. A lot of prosecutors are not aware of that. The other thing you want to make sure of is that when your client takes a test, that the chemical test was within 3 hours of the time of driving. Why this is important is in California and a number of different states, they actually set forth that the only admissible test is a chemical test that is taken within 3 hours of the time of driving. And there's a presumption that goes into effect. So it's presumed that if your client took a chemical test within 3 hours of driving, and that test was of 08 or higher, it is presumed, it's rebuttable, but it's a presumed presumption, it's a presumption that the client was at least in 08 when they were arrested, or at the time of driving. Now, if it's more than 3 hours, that presumption does not actually go into effect. So for a Department of Motor Vehicles hearing, the DMV would actually have to bring in an expert to be able to set forth the foundation as to why that person would have been an 08 or higher at the time of driving. On the criminal case as well, there is no presumption. They do not get the jury instruction that if the person in fact has completed a test within the 3 hours, that in fact that test is presumed to affect the blood alcohol or be equivalent to the blood alcohol level at the time of operation of the motor vehicle. So knowing that, look for that time element. Look for that 3 hours that you have between the time of the stop and the time of the chemical test. And if you in fact have that and you've got a DMV hearing, you could go in and do a motion for a set-aside because in fact it's not going to be an admissible chemical test underneath the vehicle code. And we'll go into that just a little bit later. So looking forward again to the breath test. The breath test has a couple other avenues of attack that may be done on it as well. Besides the partition ratio, the breath machine has what's called a slope detector. A slope detector actually is designed to measure a burp. So if an individual belches and it shows a blood alcohol that's coming up like this and all of a sudden it spikes, the machine is designed to actually indicate mouth alcohol. Does it always do it? We would hope so, but sometimes it does not. But one thing is that's important to realize is that for the proper administration of a breath test, officers are required to wait 15 minutes and observe the person for 15 minutes and to make sure that the person hasn't belched, burped, regurgitated, chewed gum, smoked, or anything of that nature, because there are different aspects that will trigger, different things that will trigger a misreading with a breath machine. For example, certain inhalers that asthmatics may use, that will give a false reading in a breath machine. Mouth alcohol will do it as well. I remember a demonstration I gave for the Judicial Council in which I actually had gargled with Listerine and then waited a short period of time and blew a 0.08%. Originally, when I gargled with the Listerine, it was off the charts. So what I did is an example of blowing into the machine, showing that it had zero blood alcohol, no reading. I gargled. It gargled and it still showed that it was off the charts. And then several minutes later, I was in 08. I did it again, and I was registering as an 08. So these are things that are important to know when you're looking at the breath test readings as well. Did your client use an inhaler? When did they actually ingest the alcohol? Other things that come into play here are, does your client have any, believe it or not, cavities? Individuals that have cavities or areas where the alcohol can concentrate and hide in there are going to have an improper breath test reading. If you can imagine that the alcohol evaporating out in the mouth is going to give a much higher reading than alcohol vapors coming up from the lungs. And what the machine is designed to do is to test what's known as deep alveolar lung air. Basically the lung air from the bottom third of the lungs, which has the highest concentration. So prior to taking the chemical test, I've always told people to go ahead, inhale and exhale, and blow out all the deep alveolar lung air that they have, and then blow into the machine, and it will knock it down by a 0.04 or a 0.05, just by doing that one step alone. And it's still a valid test. The officer can't say, oh, he took a couple breaths and cleared out his lungs and blew into it. As long as there's two readings within 0.01 of each other, so exactly a 0.08 and a 0.09, that's still considered a valid test. So doing that will help out as well. There are other things that affect the breath machine as well. Radio frequencies that are used close by. Officers are required to actually have the radios turned off because those transmissions may actually affect the accuracy of the machine. One thing that's very, very difficult, though, is an individual who has GERD. If you don't know what GERD is, oftentimes it's manifested by heartburn, heartache. It's an acronym for gastroesophageal reflux disease. And in GERD, the upper hernia, actually at the top, the bottom of the esophagus, at the top of the stomach, the sphincter muscle will actually open up and relax a little bit. And what happens with that is if the individual has consumed alcohol and it's in the stomach, what you have is a steady feed of alcohol vapor that is coming up the esophagus, blending with the air that's coming out from the lungs and giving a much higher and a very inaccurate breath test. The problem is that you really don't know, and the machines aren't set up to test for this GERD alcohol. The machines are designed to test for the mouth alcohol, the sudden spike. But with GERD, there's not a sudden spike. It's a constant emission of alcohol from the stomach contents. And the person oftentimes doesn't know if they're having a GERD issue at that point in time, because the bottom of the esophagus, approximately the last half of the esophagus, is not lined with nerve endings. So that if you have stomach contents coming up in the bottom portion of that esophagus, the person may not know it, other than for maybe the bad breath associated with the stomach contents, or a lot of burping or belching. It's only when you get into the upper part of the esophagus that the person actually realizes they have GERD and they've got the contents of the stomach coming back up. But this simple malady alone will cause a much higher breath test reading in and of itself than anything else, and the machines are not designed to detect that. So be sure to find out if your client has GERD or maybe has an undiagnosed GERD. Now, leaving the breath test, we're going to look at the blood test at this point in time. Almost all states require that if a blood test is being given, that you cannot use an alcohol swab on the arm. And in 24 years of practice, I've only found a couple cases where alcohol swabs have been used. And that's primarily been with emergency treatment in the field, paramedics, and individuals like that who've taken blood samples. Anybody that's taking a blood sample for use in a criminal prosecution must know that a non-alcohol antiseptic or disinfecting solution must be used. Failure to use a non-alcohol-based disinfectant will result in the elimination of that blood test as a viable test for purposes of criminal prosecution. Because, of course, when you're putting a high alcohol concentration on the skin and the needle is going through that, you're going to have that alcohol vapor, actually, minute as it may be, coming into the needle and the syringe and affecting that blood sample. Other things you're looking for in the blood are going to be the amount of preservative that's been used. Most places use sodium fluoride, and you need to have a preservative level that is at least a 0.10 as opposed to a 0.025, which was used a number of times. So looking at that, you want to see if the person's blood, in fact, has used that proper amount of preservative and what type of antiseptic was used to clean the arm. Sometimes people will say, well, I have a liver problem, or my body's not metabolizing out alcohol. Is this a defense? And what I say is it's not a defense, because you still have that blood alcohol level. So if the person comes back at a 0.08 or a 0.09 blood alcohol level, as measured from a blood test, and they're having trouble burning alcohol off because of missing an enzyme or having a liver problem, they still have the 0.9 blood alcohol. It doesn't change. The fact it's not burning off doesn't mean that the blood alcohol level still isn't there. So that's something that you really need to be cognizant of, and it's really not going to render itself as a defense. What you can do, though, and which oftentimes proves productive, is you can get the fluid retested. And so what you do with a blood retest is you do a stipulation for a fluid retest, and you have the prosecutor sign that, and you have the judge sign it. And what you're asking them to do is to have a crime lab, a private crime lab, go to the county crime lab and get a small quantity of the blood sample from that crime lab and retest it themselves. And what we find invariably is that on that subsequent retest, there has been some minute evaporation of alcohol or something that has occurred, because your retests will almost always, 99% of the time, come back lower than the initial blood test from the county crime lab. And that subsequent retest that you have actually is admissible in court, and you can present your evidence to show that that test, in fact, should be considered by the prosecution or by the DMV. If I have a client that's got an 08 blood test and I get them retested for the Department of Motor Vehicles hearing and it comes back as an 07 or an 06, I'm bringing that client in to testify, and I'm going to bring my crime lab person in to testify along with the results, and I'm going to get a set-aside of that driver's license suspension by showing that, in fact, that test was not accurate, and, in fact, the subsequent test showed a reading below a 0.08%. So this is just a small primer on how to deal with those two particular tests, or what you want to look for when you're evaluating those tests. The last thing that you want to do, though, is to order a crime lab packet. And this is something that you get from the prosecutor, or you can subpoena to the Department of Motor Vehicles hearing. On a blood test, it's going to be the gas chromatograph readings, showing whether or not that machine has been calibrated properly, what the calibration methods used, and how accurate it is. Likewise with the chemical test for the breath, and the breath test calibration records are going to show whether or not that machine has been calibrated every 10 days or 150 tests, whichever is earlier, what the known alcohol solution was, what the air blanks were, what the various solutions were for subsequent calibrations that were used. Important here is to look at what the known value solutions are. If the machine is getting a known solution of a 0.100 and its reading is a 0.109, even though this is still admissible, it does in fact affect your client's test, because your client's results are only coming back to the second meter, or the second reading. So your client may have actually blown a 0.0785, and they're reading up with the machine as a 0.08. Huge difference here. So if you can find that that machine is reading a little bit high, that is going to be a make it or break it at a borderline case for the DMV and also for the criminal prosecution. So you want to make sure to get that crime pack or that lab packet, look through it. If you don't know what it says or what it means, find somebody who does, confer with them, have them refer to that and tell you what, and point out to you what it is you're looking for. Use that in your negotiations with the prosecutor, or use it if you're going to be using a trial. Moving forward now, we're going to get to that readiness conference. You should be ready now, because you know now what you're dealing with as far as the chemical test. You know what you're dealing with the field coordination tests. Let's say the prosecutor, though, isn't giving you any sort of an offer, or maybe you think there's a problem with the stop in the case. And what do I mean by a problem with the stop? Was there probable cause to arrest the client in the first place? What was the reason they were pulled over for? Well, if they were involved in an accident and it was their fault, you don't have any ammunition there that you're going to be able to use. But let's say the officer said that they were weaving on the freeway. Well, the weaving has to be substantial, has to be documented. What's really nice now is, at least in the California Highway Patrol are using the MVARs, or the Mobile Vehicle Actuated Recording System. And that device actually sets up to record. It's a constant recording of what happens, but it traps and saves all of the recorded documentation from 30 seconds prior to the overhead lights going on. So what happens is, you're looking at that video, you can see your client's driving. You can see, was it good? Was it bad? For 30 seconds prior to the officer pulling the client over. Sometimes I look at that and I'm like, you know what? They absolutely need to get pulled over. There's no issues here. Other times you'll look at it and you're thinking that the police report is completely documenting a vehicle other than the one you're seeing in this video, because the one you're seeing in that video doesn't have any problems at all in its vehicle movement. It's staying within its lane of travel. Then when the officer's under cross-examination later, he's trying to say, oh, well, that must have been recorded beforehand. The machine didn't save it. But what happens is, your jury gets to see, or your judge gets to see, perfect driving, and an officer trying to explain why that perfect driving, as opposed to a problem driving, was captured on that video. I always say these videos work far more in our benefit than they work in our detriment. Various law enforcement agencies that I've worked with in the past, or worked in conjunction with, have tried to use videos for purposes of recording field coordination tests. You'll see that none of them do that anymore. Even the CHP will not do the video in front of the patrol car where the video can capture it, because the officer wants to have a free hand in writing up what the results of those field coordination tests are. Many years ago, the city of Coronado used to videotape field coordination tests, and they had a young Navy SEAL that they wanted to have do a walk and turn test at their police station, take the 9 steps out, turn around and take 9 steps back. Despite him being substantially above the legal limit, he did handstands down the line, turned around, did handstands back, and of course the jury said, well, he's not under the influence. So of course the police department said, we're not videotaping anymore. So what you're left with is the officer's ability to completely document what he wants those field coordination test results to be. Let's say you find a problem with that with the driving, though, or you think that the officer shouldn't have pulled him over, or maybe your client was just parked outside the bar waiting for somebody to come out, and the officer came up and arrested them because the engine was on. You need to bring something called a motion to suppress the evidence. Different jurisdictions will have different names for them. In California, it's called a 1538.5. And what you're trying to do is show the judge that there was not probable cause for the officer to believe that a crime was being committed. Any sort of offense was being committed. And if, in fact, the court finds that there was no probable cause to believe the offense was being committed, then you get a suppression of your client's statements, a suppression of anything that occurred after that unlawful detention, including the chemical tests and the field coordination tests. The prosecuting agency may then seek to get the case dismissed at that point in time. Whether or not, though, you choose to have that case dismissed really ultimately depends on how well your client did at the DMV hearing with you. For example, getting the case dismissed does not provide for collateral estoppel against the Department of Motor Vehicles. In California, that case is Geikus versus Zolan, which I wrote the amicus opinion on, I think, in 1992. And in that case, it held that the granting of a motion to suppress the evidence on the criminal case did not bind the Department of Motor Vehicles, and they could still proceed with their suspension. So in that circumstance, what I do is, as opposed to having the case dismissed, what I will do is, no, I don't want the case dismissed. Let's set it for a court trial. And of course, we'll set it for a trial. They have no evidence, and so the court rules and finds an acquittal on your client. The acquittal is binding upon the Department of Motor Vehicles. It really only takes about one more court appearance after your motion to suppress the evidence. But if the person is acquitted of the criminal charges, the DMV has no choice but to set aside the license suspension. I have a writ case right now that's going forward where the Court of Appeals actually reversed the jury trial, and the case is before the state Supreme Court right now, and the DMV is still trying to recognize that case as a conviction, despite the conviction having been overturned and being pending before the Court of Appeals. So we have a writ case coming up on that. That case is Van Gilder, though, versus the state of California. So that case will actually set forth some law here within the state of California once that decision and argument gets heard by the state Supreme Court. Right now we've got the motion to suppress the evidence. We're past that. So you didn't win this motion to suppress the evidence. What are you going to be doing now? Ask your client, did the officer fabricate some of the reports? Was the officer heavy-handed with your client? Do you think that there might be something in the officer's police records or personnel records that you really need to take a look at? What you're doing at that point in time is you may ask a judge to look at the police officer's personnel records to determine if people have made complaints of same or similar conduct here. When you actually do a motion, in California it's known as a pitches motion, you need to notify both the city attorney and you need to notify the prosecuting agency, and you need to notify the attorney for the law enforcement agency, and you set it in court. You also need to include a declaration from your client, and I also do a declaration from myself as well, as to what happened and why you think that this material is germane or necessary for your case. The officer then, the judge will actually then take the personnel file back into chambers along with the attorney from the law enforcement agency. The prosecuting attorney is not allowed to go back there unless you actually are allowed to go back there as well. Sometimes some courts will let them do so, but if they're allowed to go in, then you're allowed to go in. And what the court is going to do then is examine that personnel file to see if there's anything in there that can be showing that your client's statement is true and that the officer was heavy-handed or falsified evidence. One thing, though, you have to watch out for is that usually the officers can apply to get the personnel file sealed or those complaints withdrawn after 1 year. So an officer may have complaints that were older complaints and they've been withdrawn. You're never going to be aware of those unless you have a network of criminal defense attorneys that you know of who have had similar hearings in the past and know about that officer having personnel issues or complaints having been made. So that's a PITCHS hearing.
The course code is 157. The course code is 157.
Other cases or other motions that you have are pretrial motions. You may have non-statutory motions to dismiss. You may have motions to preclude certain evidence that comes into a case, and that's on a case-by-case basis. You may have a motion to preclude the preliminary alcohol screening test from coming in because the officer gave the person the admonition and told them that the test wouldn't be allowed in, or in some cases the officer never told them that it was a voluntary test. The officer didn't inform it was a voluntary test and they were entitled to take it as a voluntary test only. Failure to advise of that can also preclude the introduction of that preliminary alcohol screening test. So you may want that to come in as well. Motions to exclude breath test results or blood test results are also non-statutory exclusion motions or non-statutory motions, which are many times brought up as an in limine motion before the trial court. And those cases are heard by the trial court along with the motions to have specific jury instructions that are given, or motions to eliminate different witnesses, or motions to deem people hostile witnesses. Those all come in before the trial court, so you're going to want to prepare that as well. Let's move to the DMV side for just a minute, and with the DMV, you're looking at a very different set of facts than you are with a criminal case. The jury trial in a criminal case, as we all know, is proof beyond a reasonable doubt. DMV hearings, though, only entail actually a preponderance of the evidence. So the burden, if you can shift that burden to the Department of Motor Vehicles, you've actually succeeded and you should win. What happens if the DMV, though, doesn't grant your hearing request and continues with suspending your client's driver's license? You have two options. One option is called administrative review with the Department of Motor Vehicles. You pay an administrative review fee. You ask the Department of Motor Vehicles to set that off for administrative review in Sacramento, and then at that point in time you wait for the results. The downside for an administrative review is, number one, your client's license is suspended during that period of time. Number two is the majority of the time they will side with the Department of Motor Vehicles, which is about 98% of the time. I haven't had an administrative review come back and set aside a license suspension for at least 17 years. Also, if you do an administrative review and the Department of Motor Vehicles says, you know what, Mr. Newhart's right, or the attorney's right, and there wasn't sufficient evidence to support that suspension, what they do now is they send it back to the DMV and allow the DMV hearing officer to reopen the hearing to take additional evidence in order to support the DMV's decision. So learning that the hard way, I had filed a writ of mandate against the DMV, which is the other thing we'll talk about in a minute, filed an administrative review, and the administrative review came back and said, we're actually reopening the hearing to get more evidence against the licensee, and it actually made my writ hearing moot. So I advise attorneys at this point in time that unless your client cannot afford a writ, not to do an administrative review because it will be an exercise in futility. Doing a writ of mandate, this is not for novices. And the reason why a writ of mandate is not for novices is there is the potential that if the writ of mandate is unfounded or you have no good cause to bring the writ of mandate, your client may be ordered to pay costs and attorney's fees to the state of California if you lose the writ. So not only did they pay you for the writ was unsuccessful, but now they're on the hook for payment of fees to the Attorney General's office and the state of California. And believe me, that's probably a good way to generate a complaint to the state bar. So you really want to steer clear of that unless you really know what you're doing with a writ. But let's talk about a writ for a minute. A writ of mandate needs to be filed within 30 days from the time that your client receives the order of suspension from the DMV. A writ of mandate is filed in Superior Court with a filing fee. And now you also have to pay for fees for court reporters as well to go for writs of mandate. Once you file a writ of mandate and you get sent out to a trial court, you then have the opportunity to set it for an ex parte hearing in which to stay the license suspension pending the outcome of the writ of mandate. So you really need to have some pretty good grounds on which to do that. My win rate for writs of mandate for cases that I do for my own clients is about 85%. For cases that I do for other attorneys' clients, it's about 60 to 65%, because other attorneys oftentimes have not set the case up for what I view as writ winnability. But the writ of mandate reviews the entire proceedings from the Department of Motor Vehicles. No new evidence is allowed to be put in, either by the prosecution or by the defense. But you have the unique ability at a DMV hearing to really control what the issues are for a writ of mandate. For example, have you subpoenaed documents? Have those subpoenas been complied with? Is the Department of Motor Vehicles forcing you to take discovery at the last minute without giving you a chance to review it or giving you a chance to continue the case? Petrus versus DMV, or Petrus, the case that I had in 2010, actually dealt with the state of California, the DMV, forcing us to have a lab packet at the date of the hearing and not giving us the opportunity to review the lab packet, and then denying my motion to continue the case to review the lab packet. And in Petrus, the 4th DCA also ordered that the costs and fees be borne by the Department of Motor Vehicles. So that's something to keep in mind when you're doing the writs of mandate or doing your DMV hearing. What issues are there for discovery? Have you presented a defense? Have you presented experts to show a rising blood alcohol level? Have you subpoenaed documents and those documents haven't been complied with? I broached briefly upon the rising blood alcohol level issue because I believe that issue is the most abused issue in DUI defense today. Basically what a rising blood alcohol is in a nutshell, and this applies to both Department of Motor Vehicles hearings and to the criminal defense in the criminal case, rising blood alcohol is trying to show that at the time that the client was driving the motor vehicle, the blood alcohol level was below a 0.08%, and at the time that their blood test was given, it was above a 0.08%. The premise is that the person drank alcohol that was not yet absorbed into the blood system or the bloodstream at the time of driving. Where this is legitimate is if the person has consumed food that may actually absorb some of that alcohol, bread, pizza, anything that's porous that can absorb that, may keep beer, may keep wine in there in the stomach and do a delayed absorption. Also, if the alcohol was consumed, and I say as a rough frame, 30 minutes to an hour on a case-by-case basis within the time of driving, and that alcohol was consumed then. And then what you really want to see is that documented in the police report? Did your client tell them, yes, I had my last drink just before I drove, or my last drink was 20 minutes ago? Or did your client say, I just had 2 beers a few hours ago? Even though your client may have really had the rising blood alcohol level, if they've lied to the police officer, it's really hard to get it in. So either the client doesn't make a statement at all, which is the best option, or if they make the statement about how I just finished up a beer and got in the car, those are both things that you can use for a rising blood alcohol defense. What really, really has knocked this out from really being effective is a number of attorneys trying to use this on high blood alcohol cases. They may have somebody who is double the legal limit, or even 2.5 times, a 0.16 or a 0.20. And they're trying to say that, oh, you know, just before my client got in the car, he drank a 1/5 of vodka or a 1/5 of whiskey before he got in the car. And so he didn't have that in his system when he was driving, but by gum, he had that in there when he got pulled over, and he was tested later on. But he was below an 0.08 at the time of driving. So what they think is that the prosecutor or the jury is going to come back and say, you know what, he's right. That wasn't fully absorbed. That's not really what happens, though. A jury listens to that and says this person is either irretrievably stupid or congenitally insane and drinks a 1/5 of hard liquor before getting in the car and then drives and wants us to reward this activity with a not guilty. And that does not happen on a rising BAC at a high level. You really, to maintain legitimacy and to maintain your own credibility with the law enforcement agency, with prosecutors' offices, with the DMV, limit your rising blood alcohol cases to cases that are 1-1s, 1-2 at the most, at which you can corroborate and document that this was a rising blood alcohol case. One thing that really comes in and is beneficial here is if your client says that they only had 2 beers, but you found out that those were 2 Belgian beers or 2 microbrews that had a much higher blood alcohol level, or I'm sorry, a much higher alcohol content, that actually really will help you out, because some of the Belgian ales have a 0.11 or a 0.10 or a 9%, some of the microbrews. When we're dealing with a standard drink, what we are dealing with is 12 ounces of 5% beer, 4 ounces of wine, or an ounce of 100 proof or an ounce and a quarter of 80 proof alcohol. That's considered a standard drink. So if your client has 12 ounces of a microbrew that's about 9% or 10%, that's actually counting as 2 drinks in one. So your client saying, hey, I only had 2 beers, might actually be very correct. But those 2 beers may actually give a rise of a 0.08% and actually put them over the legal limit. How alcohol affects different people is in different ways, but alcohol absorption is something that we really don't know. It's not an exact science. Alcohol absorption is depending upon what you've had in your stomach, what type of alcohol you're drinking, what your food content is, how recently you ate. That really affects this. There's really almost no way to document that unless we do a recreation of that in a lab. Alcohol burn-off, though, is much more scientifically established at about a 0.02 or a 0.025 per individual. Also, body weight and whether or not a person is male or female also greatly affects the amount of alcohol absorption. For example, a 100-pound female is going to get twice the level and twice the blood alcohol level of a 200-pound male. So that's also something to bear and keep into mind when you're doing that. There's a number of different charts and graphs that are available online or through different publications. You can plug in what your client had to drink, what their body weight was, what they had to eat, and be able to formulate a rough estimate of that. Hopefully this has been of benefit to you, and like I said, if anything comes up where you need assistance and you look at these things and you really are having trouble understanding it, find somebody who's a really knowledgeable practitioner in that area. See if they'll take a look at the copy of your police reports and give you some different advice. I do that with a number of guys, give them copies of motions, help them as far as how they're trying to deal with their DUIs or their DMVs, and that's really the best way to deal with it, and that way you've got somebody who's assisting you and you're able to represent your client to the best of your abilities. Thank you.